or in court procedure. You don't have to nursemaid him or carry him by the hand or stand around him all day and night in order to decide what he should or should not do. So, I mean, I can understand you saying, it's your fault, but if we don't, I have clients, not clients, but defendants who come here who have mental problems and so forth. Maybe in those cases it's necessary for the lawyers to do certain things. But I think that is not a very good presentation or logical reason to excuse not following court order because you didn't tell him. Move on, please.
All right. Again, let me say that it's not an excuse I'm giving. It's, again, mitigation, Your Honor. And that's why I believe that in this particular case.
All right. I'm sorry. I said I wasn't going to interrupt. Let me see if I can hold to that. Go ahead.
Okay. So, thank you, sir. Finally, in getting down with this, I think, too, that the court ought to give credence to pretrial services because, they're in the case, they're aware of the case, they understand the case. And this,
I hate to interrupt. I don't get the pretrial service until we decide the issue of whether or not there was an abuse of discretion. Pretrial service only come into play as to what their recommendation may be as to any bond conditional modification, what I should do with that. And if we get to that, then I'll let you make that argument. Okay?
Thank you.
All right.
Just so you'll understand, my understanding was that was prepared before the hearing yesterday, and I just wanted the court to understand that I felt like, again, that could be an element of abuse of discretion.
I see.
So please forgive me.
Okay, I respect that, man. Go ahead. I'm sorry.
No, sir. That's okay, sir. Thank you very much, Your Honor. So finally, Your Honor, what I want to say to the court is that in this particular case, I do not believe in my heart that Mayor Kilpatrick just totally ignored the court at all and just said to heck with it and just walked away. Now, in all the cases that we've had and what's happened in this case is he has been required to do some things and has been given some leniency in other things. The requirements that are different that I understand, and I haven't practiced here in Michigan, but in talking with other lawyers that do practice here, is he was required to show up every day on every hearing, no matter what it might have been. He was required to be there. And other cases, my understanding is some judges don't require that. On each occasion that Mayor Kilpatrick was asked to be there, not only was he present, but he was on time. And so I think that is a key factor in this, because what we're looking at really, what we're really looking at on release is the following. Is he a danger to society? Is he a flight risk? I mean, that's what it boils down to. So if you take a look at the record in this case, let me show you this if I can. If he's been there every moment, if he's been there every time, on time, that to me shows respect to a court. I know because my Johnny Six-Pack, he wouldn't show up until a week later when I had court. But he's been there, and he's been there. Let me show you something else that I think is important. When this issue came up, and I learned about it through the news, we went to see Judge Giles, and I don't hold my to the date, but it was like last Tuesday or something. We went over to the courtroom with the prosecutor, Mr. Moran. I think what's important in that is the judge knew, and we told him that he was out of town. I won't go into that right now, but he was out of town with permission from the court and return.
Okay.
I think the important part about this is this. Judge Giles at that time didn't say, I have a concern about him being a danger, or I have a concern about him not coming back, so therefore we'll continue the hearing for your request. That was our request. We'll put it off until yesterday on Thursday. So a week or better passed. Nothing was done during that time period. I would take it from that Judge Giles is saying, and I'm not trying to read anything into his mind, but I would certainly think that he is saying, I believe he's coming back. I don't believe he's a danger to anybody, and I don't believe he's a flight risk, or else he would have issued a warrant at that time to pick him up. So I think going back and looking at the law in this case, that while Judge Giles made reference to some things that he did and how it made Judge Giles feel, I still believe the law is very clear in those cases that I cited that in this particular case that he's entitled to a reasonable bond and that he is not a flight risk or a danger to the community. Now, with that in mind, finally, I want to add this. The prosecutor was asked yesterday, and I'm not trying to put words in their mouth. You got the transcript, so don't hold me to the exact words, please. But the prosecutor conceded yesterday that even in light of what took place, they didn't necessarily move for the revocation. They moved for a change of conditions. Now, I would submit to the court that who would better know this case than the prosecutor, who would better know this case than the defense, and with that in mind, I believe that once a recommendation is made by a party, it should be considered, and I don't believe that it was. And I believe that also is abuse of discretion. So with that, Your Honor, I would say that we would ask, please, for this court to reinstate the bond. I think this court can do that. I believe the court can do whatever it deems proper and necessary with any changes or conditions of release that you can attach to that bond reinstatement. And we ask the court to please consider these arguments. If there are any questions, I'll be glad to answer.
I'll thank you for your comments. I'll give you a chance to respond and hear from the prosecution.
Your Honor, thank you for your time.
Okay, thank you.
This court knows the law much better than I do when it relates to the concept of what an abuse of discretion is. And the court's familiar with the cases, but to me, my understanding of the law of an abuse of discretion requires a showing that there is a perversity of will and logic, that the decision is made from passion, bias, prejudice, not logic, not common sense. And that's the definition in Michigan of what an abuse of discretion is, which the court was required to find to modify the bond set by Judge Giles. I find it interesting that counsel for the defendant says that Judge Giles abused the discretion yesterday in making his decision to remand the defendant on the one hand, and yet he contradicts himself because he says that on the 28th of July, when Judge Giles was informed about the violation of bond on the 23rd by going to Canada without prior approval from the court, Judge Giles did not issue a bench warrant, did not require the defendant to immediately return from Florida to face him in court. He said, I'll deal with it when he returns. It shows a deliberative process that the judge went through and said, didn't fly off the handle, didn't have a passive response, didn't have a response based on passion, but a response based on reason, and said, fine. He's out of town, I'll deal with it when he gets back. That is the very definition of discretion. Now, counsel wishes to paint this whole episode that took place yesterday in court as a one-episode deal where the defendant was punished because he went to Canada and didn't tell anyone. And that's not what transpired. What transpired was a series of events. First time in May, there was a modification of the bond where the defendant's bond travel restrictions were restricted even more. The Judge Giles knew that. He restricted them. He required him to give notice for professional travel, 48 hours notice. All he had to do was send a notification in because he, Judge Giles, was concerned about the liberal nature of travel that the defendant had. Then in July, on July 25th, we had a hearing about...
I'm sorry, what kind of conditions were said about notification? I mean, time, place, what was that about?
At the arraignment on the warrant, the conditions were he had to